Morning, everyone. Welcome to the Q&A today. I will start with the disclaimer of we are light on questions. So if you have ones that you were not able to submit by the deadline, feel free to put them in the chat. We will have time to answer them if we are able to answer them. As always, this is general information. It's not legal advice. The only person you can get legal advice from is your association attorney. And we will tell you if we can't answer a question or if it's asking for information that we cannot provide. We, Condominium Law Group, recently moved our offices, so yay. We're getting it settled in, and we didn't move very far, but if you need our new address, reach out to Chelsea at info@condolaw.net. It's also been updated with Google, so you could just Google it. As always, the chat function is intended for questions or requests for clarification and commentary. It's not for legal advice, and it's not for discussion that you would find on other message boards or forums. I think that's a non-issue now, but we still like to say it. You can review our recent Q&A videos for primers on upcoming legislative changes. Some of them for Ukiah communities took effect already. Some big changes coming January 1st, 2026. And then, as we've been talking about, Ukiah for All will apply to all in its entirety January 1st, 2028. If you have any suggestions for topics on these primers regarding the new statute, you can email info@condolaw.net with your suggestions. WSCAI did just release or produce a resource guide about Ukiah for sale. I think there's a discount if you're a member of WSCAI. So if you want more written out information, it is a digital only version, but you can access that through WSCAI. CA Day is coming up on October 18th at the Seattle Convention Center, I think. And I will be presenting again this year. I will be presenting with Michelle Weaver from Best Management. We'll be talking about the upcoming meeting changes and the new statute and how that applies to everyone and some best practices. There is a wide range of topics, and I do know that the changes to Ukiah in various areas are going to be a hot topic. So if you want to learn more about that, sign up for CA Day if you're able to attend. And as I mentioned, the changes to Ukiah already took effect for Ukiah communities. And stay tuned for more discussion on what those changes are. And with that, we're just going to jump into our questions. Like I said, we don't have a lot, so I know some have already started to come into the chat. So keep them coming. Our first question today is, has the LAC, which is the Legislative Action Committee, seen legislative direction towards subletting of condos which could override CC&R rules? Short answer is no. The statute does provide for all associations right now that an association cannot restrict the number of unrelated occupants in a unit. That could impact subletting depending on your specific situation and override your CC&Rs. Otherwise, there's no statute or discussion to change the statute to require an association to allow subletting or prohibit it or even deal with it. So Ken, unless you have anything to add, I think the next question is yours.
Yeah, well, I'm not sure if the person asking means subletting in terms of allowing additional roommates to move in, or whether it is literally a tenant moving out and then renting the apartment to someone else, or the condo unit to someone else, which is actually usually prohibited by most leases anyway, completely outside of the condominium declarations. But yeah, we can't, we don't think the LAC or the legislature is actually dealing with that issue. They are dealing with issues related to the number of unrelated persons living in a unit because they're trying to combat homelessness. So second question, is it a preferred path for HOA attorneys to enforce back payments through condo rider clauses. And we have no idea what's being asked here because we don't know what a condo rider clause is. There certainly are provisions in most declarations already that provide enforcement mechanisms for delinquent payments or delinquent assessments. And that usually includes up to and including a foreclosure on a property to repay the association. And there's a statute in the Condominium Act, which is 6434-364, which also details the liens which are created automatically under the statute and the lien rights and foreclosure rights which the association has. So that's a place to look if you're wondering. And if you've got delinquent assessments, you might want to consult with an association attorney about how to collect those. So, anything you want to add, Katie?
Nope. So the next question is, in 2022, our HOA was told by an attorney in order to add the restriction to the number of rentals allowed in our community by changing our CC&Rs, we would need a supermajority of 100% of the votes in the association. Does that still apply now? Can we restrict short-term rentals from using our amenities, such as a pool, golf course, and trails? So first, as I mentioned before, we can't provide legal advice. We cannot tell you what is required for your community without looking at your governing documents and the applicable statute. Generally, and we'll go into the different applications for each type of statute, is generally if you're a Ukiah community, so a 6490 community, you can adopt a restriction on rentals with 67% approval of the owners unless your documents have a higher percentage required to adopt a restriction on use. So some documents will specifically call out if you would like to amend your documents to include a restriction on use, you need 90% of the owners to approve. If you're a Ukiah community and it's silent, then it's usually the 67%. Ukiah also has specific allowances to adopt rental restrictions in order to comply with the banking industry standards for mortgages. Additionally, there are specific provisions in Ukiah that prevent a single owner from preventing the rest of the association from adopting amendments. So under Ukiah, it's probably nearly impossible to have 100% approval requirement because it would hinge on a vote from a single owner that could throw the whole thing out the window. So if you're a Ukiah community and you want to adopt rental restrictions, it probably is easier than some other communities, but talk to an association attorney. For communities under the old act, which is RCW 6432, the declaration may be able to be amended regardless of restriction on use for whatever is required for any other amendment. Those documents are usually more bare bones and more silent and have a lower amendment threshold. They can also have a higher one depending on who wrote it. So look in your amendment provision there. For communities under RCW 6434, restricting rentals is a restriction on use. This means that it is likely that the statute and the declaration require approval of 90% of the owners and all affected owners to amend the declaration to restrict short-term rentals. And that can sometimes mean effectively 100% of the people. Under the HOA Act, which is 6438, you may need 100% of the owners. This was addressed by a case in the Washington State Supreme Court called Wilkerson v. Chihuahua. We've gone into the details of the case in several other Q&As, but the key question in that case is whether a restriction is new or a change to an existing restriction, and whether or not the owners were on notice that the community could adopt additional restrictions on the use of a unit or a lot. In Chihuahua, the court ruled for this particular community that rentals were allowed and anticipated by the original developer in the CC&Rs, and that the community had a long history of rentals, including short-term rentals, and that the community could by vote, or the community by vote could not take away from an owner the right to lease. These cases that discuss short-term rentals and rentals in general are very fact specific. If you're creating a new restriction that someone could not have anticipated, you're going to need basically 100% approval. If there's something in your documents that say, like, rent for rent signs are restricted or something like that, that would give an owner an idea or an inkling or some sort of notice that there could be a restriction on rentals, that may change the answer. So our courts, just so everyone knows, have held that short-term rentals are a residential use, not a commercial use. We have some people who try to make the argument, well, we have a prohibition on commercial uses in the lots or the units, so therefore we can ban short-term rentals. That would not be successful unless the court decides to change their mind. There are cases from other states that have held that an association could charge extra fees to owners who had rentals because they demonstrate an additional cost associated directly with those rentals, such as higher move-ins, higher use of the elevator, etc. Regardless of your statute, you generally cannot treat tenants as a different class than owners. You can say that only occupants can use certain amenities. This would mean that an owner who's renting out their lot or their unit could not use the pool if they have a tenant who's also using the pool. But you can't say just because someone is a tenant or a short-term renter that they can't use the pool, parking, trails, etc. Ken, do you have anything you want to add?
Yeah, so more specifically to, can you prevent short-term rentals from using the amenities like pools, golf courses, and trails? I, I think the answer is generally no. There have been cases, at least one out of California, where it was held that the association could charge a fee to the landlords that were doing short-term rentals because they could demonstrate an actual cost to the community based on the short-term rentals and their increased use of boat ramps and other common facilities. But again, very fact specific, and it goes against what I would consider the general rule, which is tenants acquire the same rights to use of the property as the owner when they rent the unit. So the next question is it permissible to utilize replacement reserve funds to pay the earthquake insurance deductible in the event of an earthquake that damages the community building? So it's a really specific question, but one that I think I can answer with the general rule. And the general rule is that the association can use reserve funds to pay for almost anything. Use of reserve funds just requires the two board members to sign that the withdrawal can be made from the reserve account. The question really isn't whether you can use the money, it's whether or not you have to notify all the owners that you have used the money for a purpose other than to repair or replace a reserve component. So if you use the money for the earthquake insurance deductible or any regular insurance deductible or to buy insurance, those are all uses of money that the board would have the legal authority to do. But if they did that, they would have to give notice to all of their owners that they have used the money for that purpose. And unless it would cause a unreasonable hardship on the owners, they have to have a plan to restore all those funds within 2 years. So the statutes have that, written into the provision and, basically use of reserve funds other than for reserve components. I think it's 6434 384 under the Condo Act. It's something like 6490 560 in the Ukiah, but it's, the board has a lot of discretion on how to use money. It's just whether they have to inform the owners. So if you have anything to add on that, Katie?
The only thing is I put the reference to the Ukiah statute in the chat for anyone who wants to look at it.
Oh, okay, great.
Um, so moving to the questions in the chat. As I said, we can take more, but the first one is, please discuss what amount would constitute a reasonable daily, weekly, monthly fee for imposition by a board against a member for violating a rule of the association. So first, I'm going to clarify the difference between fees and fines. So I think this question's actually asking about fines for violating the rules. Fees are different. They don't require notice and opportunity to be heard for the most part. They are for more costs incurred by the association or for delinquent assessments. For a violation of a rule, you usually assess a fine, which is after notice and opportunity to be heard, basically a penalty for violating the rule. And what would constitute reasonable is really going to depend on your type of community, who's in your community, and what people are willing to pay, and where your community is located and what was violated. Like, what is the rule? Um, so we won't be able to tell you like $25 is reasonable across the board. But some things to take into account are if the association will also be fined by a government agency for the type of violation. If the answer is yes, you can use whatever that fine would be to pass it on to the owner. We, for like our downtown communities, we can see downtown Seattle, we'll see fines around starting at couple $100. For our more rural communities, we see $25. You want to set the amount at what will gain compliance. Fines are not a intended to be a revenue generating stream. They're supposed to be an incentive to gain compliance and stop violating the rules. So if you have owners who are never going to pay a $500 fine for not mowing their lawn, but they may mow their lawn for, if it's like a $25 fine, that may be reasonable for your association. Fines also have to be reasonable when viewed after the fact by a third party. So you can put whatever amount you want, but if it's challenged and a judge looks at it and says it is absolutely unreasonable to have a $5,000 fine for an unauthorized modification, then that will help answer your question. We have seen for like rental violations, we have seen courts say that a $1,500 fine, because that's how much the rent was for the rental violation, was reasonable because that's the benefit the owner was getting. So it'll really, like I said, depend on the type of violation, your community, and what the goal is. Ken, do you have anything to add?
Yeah, I would offer there's also a difference between the fine that you publish in your rules and the fine you actually assess. So you can't assess a fine absent notice and an opportunity to be heard. And the amount of the fine should be established by the board after the hearing from the owner. So if there were circumstances that the board felt were, unfair or not within the control of the owner, then it would be appropriate for the board to reduce the fine or waive the fine. And, I've seen clients who will have in their rules that they're just going to double the fine every time. And it might be reasonable the first, second, or even third time that the fine is assessed, but you start getting fines that are in the $1,000 and $2,000 range, and it would be difficult for me to stand in a court and argue that those were reasonable. Reasonable is a broad range, and it's usually easier for me to say something is outside that range than to pick a number inside the range. So is $25 reasonable? Almost certainly is reasonable for most, but it may not have the incentive to get people to cure a problem. Because we do have some clients where an owner will have a violation and like having too many cats is one I remember. And the owner was simply willing to pay the fine in order to have too many cats. Um, I also try and encourage people to look at whether or not the fines are making a difference. Um, we've got clients where assessing the fine over and over is not producing the correction which the client wants. And if you're going months or years before you start looking for other remedies to the problem, then the fines start to look less reasonable because you're not consistently enforcing something. I've got clients who will send in and tell me it's the fourth violation, but it's been four violations spread out over 3 or 4 years. So I guess part of it is you need to sort of feel like what is reasonable for your community, because it's going to vary by community and it may vary by the kind of violation.
Great. I'm going to let you take this next one, which is what are your recommendations regarding associations purchasing alcohol for social events?
Well, if you're going to purchase alcohol for a social event, first I'd want to make sure you had insurance, which would cover that. Your insurance agent may have um, the ability to tell you if you have coverage, and it's also possible to buy coverage for single day events, because I know there are clients of ours that require owners to buy special insurance to protect the association when they rent the cabana or party room and serve alcohol. Uh, Personally, I'm opposed to associations buying alcohol because I just see it as creating an unnecessary risk. But that doesn't mean that there wouldn't be circumstances for some communities. I mean, if you are a golf course community, you're very likely to be buying alcohol for some events. You should have appropriate insurance for it. If you've got employees, and you need to then make sure that they are properly trained in the dispensing or serving of alcohol, because there are laws about over serving that can also create risk. Um, so you know, I'd say as a general rule, I would avoid it. And if you're going to do it, make sure that you have insurance protection.
Also, one thing I thought of is if you're selling it, you might need a permit to sell it. So check with your locality.
I would say if you're selling it, you are increasing the risk really substantially. And I'd strongly recommend against that.
All right. Next is it reasonable for an association to charge a partial move-in fee for the staging of a unit? While there is little to no administrative paperwork involved, there is still wear and tear on the building, plus the time, trouble, and aggravation of an on-site person to monitor the activity. So without looking at your documents, we can't say if there's even an ability to charge a fee, but I think if there is costs for wear and tear with the staging, you could probably build that into your overall move-in fee for the unit. Because I mean, the time for an on-site person to monitor it, if it's a management company, that is actual time that the association would probably be charged for. So while there's no changing of residents or anything like that, I think if you just build it into your move in, move out fee for your association, you would cover those costs. Ken, do you have a different perspective or additional information?
Yeah, I think the key, I agree with Katie, is that if you have documented expenses associated with those moves, then it's reasonable to have a fee to cover them. We have clients that have fees for move in and move out where, a person and all their furniture and belongings go. I've got at least one client with a fee for staging because it does involve tying up the elevator and padding the elevator and the resident manager's time to coordinate. We've got at least one client that has a move-in fee where there's no furniture move. This is, so if you had a short-term rental or a rental which is furnished, those people are moving less in and out, but there still was the administrative time for the resident manager tied to sort of getting the people oriented and moved into the unit. So the what I like to avoid is something that appears to be a revenue stream the association is trying to extract from their owners. What I am supportive of is recovering actual expenses that are incurred by an association because of individual owners.
All right. So our next question is, does the board need owner permission to contact an owner's attorney to notify them the owner's account is delinquent? So I think this question's too specific for us to answer fully, but I think we can provide some general comments. First, if the owner is delinquent and is going to collections with your association attorney, you should tell your association attorney that the owner has an attorney because there may be limitations on how the attorney can contact them. Um, the process for collections generally is very, especially as Ken mentioned earlier with liens, is very set out by statute. So where notices need to go is set by either your collection policy, the statute, and the declaration. And unless that attorney has some sort of like power of attorney or specific authority to act on behalf of the owner, the default should be to contact the owner that their account is delinquent. Um, and then the owner can decide what to do from there. If the association is contacted by the owner's attorney, that's a different question on how to communicate and who to proceed with. Ken, do you have anything you want to add?
Well, this starts to get really fact specific, which means we can't give good advice. But there have been cases where a court admonished an association because they did not use known contacts to communicate a delinquency to an owner, whether it was an alternate email or phone number or a family member. So, depending where you are in the process, I would say it probably is appropriate for someone to reach out to the attorney, whether it's the board, the manager, or the association's attorney. I'm not sure. That would depend on the facts. It also really depends on whether you're in some other dispute with an owner. So if you are in the middle of litigation with an owner or in a dispute involving attorneys related to an architectural control request, and then the owner stops paying their dues, it's certainly relevant factually to the dispute, and someone needs to advise uh, the attorney. You don't start a collections action independent of that other dispute which you're already involved in if there's an attorney going.
All right, the last comment in the chat so far is related to your question number two, Ken. It looks like it's clarification that says a condo rider is a clause in all deeds of trust in Washington stating that the lender may pay any past dues, fees, assessments, or fines of the mortgagees. I don't know if that changes or impacts your answer.
Well, I'm not, I'll say, still not sure what that means from the standpoint of the association. Under the statute, and I would say under that rider, if an owner is delinquent, the bank can cure the delinquency for the association. And that happens fairly routinely for new act condominiums, and it will happen under Ukiah communities because the association's lien has priority over the mortgage for the first 6 months. So what the statute does and the condo rider does is basically say that the bank has the ability to cure the debt to the association and restore the bank to first position on the security of the real estate. And so it is, I would say, very common, and it's not something the association has to get involved in. Other than that, the association is required to tell the bank when requested how much money is owed. And if the bank offers up the money, then the association is required to accept it and bring the unit current. And it does seem a little weird that the bank can pay off the loan and the delinquency disappears. It doesn't mean it's not going to be delinquent again the next month, because if the owner's still not paying, then you'll have a delinquency the next month.
All right. The next question is there any law against two board members from the same unit being, sorry, is there a law against two owners from the same unit being board members or officers, or does this depend on the HOA's CC&Rs? Off the top of my head, there is no law. It will depend on your governing documents. As a best practice, we usually don't recommend it, but if you're a two-unit condo and you require three board members, you kind of don't have a choice. But like I said, no law. Um, Look at your governing documents, but maybe try to avoid having two owners from the same unit control the board. Now, if two owners also own a second unit, that changes the question because they're different units. But Ken, do you have anything to add?
Just that there is no law if the community wants to elect two owners from the same unit. I'd like them to know they are electing two owners from the same unit, but we have some clients who are very content having, a husband and wife, for example, who are serving both on the board. The communities trust them and is willing to elect them both. We don't like the concentration of power, and we do prohibit it in our bylaws that we draft for our clients, but there's no law against it.
All right. And I think with that, unless another question comes in the next 30 seconds, we will give everyone back 28 minutes of their day. Thank you all for attending today. And if you have any questions, submit them to info@condolaw.net for next week's Q&A. Thank
Right.
you
Good
all.
night.